All right, so I believe we're recording now. So we're looking at the forms changes that were effective as of yesterday, July 1st, 2024. And these are forms by the North Carolina Association of Realtors. That's where our forms come from. There's one specifically, though, that we're going to look at that is by the North Carolina Real Estate Commission, and it is a brand new form. I know you don't do as much land as, you know, what me and Amy do, but it's specific for land. And it is required. It is not required by law, but it is required by contract. They've updated the Form 12T to include this thing. And it is essentially a residential property disclosure, but for land. It's a vacant land disclosure form. So whereas no disclosures were required for vacant land previously, now it is. So we'll look at that too. But most of everything we're going to look at are updates to pre-existing forms. Let me share the screen here real quick. All right, can you see my screen?
Yes.
Try to move a couple things around here real quick. So this is the document that I sent to you guys back a couple of weeks ago. And this highlights and outlines, details all of the major changes. And all these changes, most of these changes are from the NAR antitrust settlement. I know there's some traffic in the background. Can you hear me okay, or is there a lot of background noise?
No, I really can't hear any background noise.
Okay, good. All right. So let's start with the things that we are going to use the very most. And I'm actually going to start with buyer's agency agreement to begin with, because there's a lot of really important changes on the buyer's agency agreement. Then we'll come back and look at our offer to purchase and that type of thing. Excuse me. So this is Form 201. The numbers of the forms have not changed. And this is still the marked up form. So obviously when you pull the form up now in dotloop, which I've already updated all of the loops or templates in there, you'll also see that there are a couple of new templates. I'll show you that real quick. When you go into your dotloop now and you go to create a new loop, you'll have a residential buying and a residential listing loop. We're going to call this test so you can see. So when you go to add your loop templates, oh no, they're not showing up. So I lied to you. I have to figure out why that didn't show. I made them last night, but you will have a residential residential buying, residential listing loop. You also have a vacant land buying and a vacant land listing loop templates. Okay. I don't know why that didn't update. I'll have to troubleshoot that here in a bit. But back to our forms. So I'm not going to read this whole thing to you, but I'm going to read most of the changes just so we can talk about it afterwards. There's actually a whole other page added onto this now. It's a 7-page document. And after, some of this strikeouts and stuff are taken out, it may go back down to 6. I'll just have to pull that up and see. But the top doesn't really change. All this is exactly the same as it was. But we have several new items here. So very first page, very first thing, buyer represents that as of the effective date of this agreement, first and foremost, buyer is not a party to a buyer representation agreement with any other real estate firm. Then notice that doesn't say specifically an exclusive buyer's agency agreement. It says buyer's representation agreement. And that's important because obviously now, sites like Zillow, who work specifically with agents trying to get buyers, right? They make their money, or a lot of their money, on sending these buyer leads to agents. And so there's what's called a Zillow buyer's representation form now. And it essentially is a non-exclusive buyer's representation, which we do have the option for with the in-car forms as well. We'll look at that. But this top statement says the buyer is not a party to buyer representation agreement with any other real estate firm. That means anything. The Zillow buyer's agency agreement, actual in-car buyer's agency agreement, nothing. Okay, so by them signing this document, they are consenting that they are not a party to anything. Buyer has received a copy of the working real estate agent's disclosure and has reviewed it with the firm. That's going to be important. Now, that's not a new thing, but it didn't say that straight up on the buyer's agency agreement in the past. Okay, we all know that we're supposed to do that, and we're supposed to review all of these documents with our clients. But some people are better at doing that than others. We're going to have to make that a priority going forward. Buyer has disclosed to firm information about any properties of the type described in paragraph 1 below that buyer has visited at any open houses or that buyer has been shown by any other real estate firm. Now, why would it say that? Any idea? Why would it matter if they've been to an open house or if they've looked at a property with another firm?
Well, I would say, and I could be wrong, but because um they have still like at open houses, they're encouraged sometimes to sign stuff.
Right.
So in an open house, if they have no representation, they may sign something that they don't even know what they signed.
That's very true because, I mean, in theory, at an open house, anybody that comes through there, they should have a working with real estate agent's disclosure signed. The agent should, right? The big
Yeah.
thing on this, couple things. Um, the last statement here, buyer has been shown by any other real estate firm right here. One of the new things you're going to see as we go down through here is that before you can show a property to a buyer, you have to have a buyer's representation agreement in writing signed. Okay. So that means if they have been shown any other properties, they should have a buyer's agency agreement with that firm, which means we cannot help them as long as that buyer's agency agreement is in place. They would have to terminate that agency agreement.
We can't even show them property, period, from what I understand, correct?
That is correct. Yeah, because they have agency with another firm, and we can't show them property, period, without a buyer's agency signed. Now, the first part of this is more geared towards who brought the buyer, so to speak. And a firm could argue, hey, they came to my open house. I showed them this house. Even though you wrote the offer, I'm procuring calls. Right. So that's
Right.
what that first part is really trying to get at. But these are all three new big things at the very tip top. Now, a brand new thing that was added, buyer is or is not working with a relocation company in connection to buying a property. Have you run into a relocation company at all? You know what that is? Know what I was talking about?
Yeah.
So oftentimes it's a corporate relocation company. And I've actually had this 2 or 3 times in the last couple of years where a client reaches out to me. They're interested in buying a house. It always seems like they're, have a pretty healthy budget when this happens. I'll work real hard for them, get a bunch of stuff together for them, and maybe even show a few properties. And then come to find out, well, the company that they work for is using a corporate relocation company to help them move. And what that means basically is that the company they work for is essentially getting a cut and getting a reduced rate for them using that particular company. And so therefore the buyer doesn't get the benefits and the bonuses and the reduction in, costs and that kind of stuff that they would if they don't use that corporate relocation company. Does that make sense at all?
Yeah,
So,
that makes
for
sense.
instance, sometimes the relocation companies, we'll pay $3,000 towards their settlement expenses. Well, maybe I would pay $3,000 toward it. You didn't ask, right? But this is an issue, and this is an ongoing issue. And oftentimes, these buyers don't understand that they have to use that company if they want those benefits. That's what their employer tells them, at least. And so, therefore, you've done all this work, and now you end up having to lose a client because of it. I've lost 2 or 3 clients that way. Cool so far?
Mm-hmm.
Everything here in this section is the exact same. When we get down to compensation of firm, this changes a little bit. So one thing they want to make sure of is that we put a specific fee in this line where we say it shall be in the fee of or the amount of. It wants either a specific dollar amount or a specific percentage of the sale price. And they don't want any tiers. I guess some people at some point were putting, 2% for this type of property, 3% for this type of property, things like that. They just want a specific dollar amount or a specific percentage. That's it, period. Nothing else can you put on there.
So how, and maybe we're getting to this if we are, just hold the question for later. But typically what I would put there is whatever is advertised in the MLS, and I know we can't advertise in the MLS. So that way, the buyer wasn't having to pay in addition to that. So, and I know there's no set, like anybody can put whatever there, but I mean, how do you kind of make that determination?
So that's a good question, and you can't, right? So what we have to decide now as buyer's agents is, what are you worth? Right? This is my fee. This is what I charge, just like you do when you have a listing, right?
Yeah.
You say, this is what I'm going to charge you to list your property. And everything's negotiable. If you go to a seller and they say, well, I don't want to pay X%, you offered me 3 bananas, I'm only going to pay you 2.5 bananas. And you can either decide if you're willing to set 2.5 bananas or not. Do you want the listing or not? So same thing here now with the buyers. If you put on that you're going to charge them 8 bananas, they need to know that there's a possibility they're going to have to pay you 8 bananas at closing.
Okay.
And that's no different than how it has been technically, because
Right.
technically the buyer's always been responsible for the difference between whatever was put on that line and whatever was offered by the cooperating firm. They're just trying to make it crystal clear where there can be no questions at all about, is the buyer liable for this or not. There is one other change on this we'll get to in just a second, though. But whereas it used to say firm shall seek the firm, now it says firm may seek the fee from a cooperating listing firm. Okay, so that's our first remedy. We may seek. We're not required to seek. We may seek. Right? All right. Buyer agrees the firm shall be entitled to receive same in consideration for firm services hereunder, new section, provided that any compensation paid by a cooperating listing firm or seller shall not exceed the amount of the fee unless otherwise agreed. So what that means is, if I put 3% of the purchase price on this line up here, and the listing agent contacts me and says, hey, look, we're offering 3% and a $2,000 buyer's agent's bonus. You cannot accept that $2,000 buyer's agent bonus unless everybody has been made aware. And there's a form for that, Form 770. We'll look at in a few minutes. Okay. It's all about disclosure. If buyer purchases a property where the compensation offered by the listing firm and or seller is less than the fee, or where no compensation is offered, then the buyer and the firm agree that the buyer will pay the difference unless prohibited by law. The only difference on that here at the moment would be for a VA loan. It's the only time I can think of that it may be prohibited by law, though there is a temporary stop on that, so to speak, where they are allowing VA buyers to pay buyers agents temporarily while everybody figures out how we're actually going to navigate all this. Prior to making an offer, that's the key here. Firm will inform buyer if the compensation offered is less than the fee. So what that means is, if I put 3% on this buyer's agency agreement and you're going to go show a home, I'm going to go show a home, we'll say, and the agent reaches out to me and they say, hey, look, appreciate you showing this. We're going to offer you 2.5% as a buyer's agency fee. I have to let my buyer know that before we make an offer. It doesn't technically have to be before we see the property, but before we make an offer, I have to inform my buyer that there's going to be a 0.5% difference if we submit this offer and it gets accepted, that they're going to have to pay out of pocket. Does that make sense?
Yeah, that makes sense.
Can you go back to that listing agent and negotiate your fee?
I don't know. Well, I mean, I would know. I don't know what the new rule is.
The new rule is absolutely you can, but do it before you place your offer.
Okay, because I remember you saying there's a form for that. Is that 770?
There is a form. It's Form 220, which we've been used before, but Form 220 has been completely remade. It looks nothing like it used to. The entire page is yellow now because it's a brand new form. They kept the same number and then they used it for the same purpose, but all the text in it is completely updated. Excuse me. So really, this should be negotiated before you show the property, not just before you make an offer. Because what we want to do is make sure that there is no confusion as to the association between our commission and our offer. right? Our
Right.
commission still cannot be part of the offer. I can't say, hey, look, here's our offer, but we only offer this amount if you offer me 5% buyer's agency commission or some silliness like that. So we want to, go ahead and navigate that up front, hopefully preferably before you ever show the property.
Okay.
If additional compensation, we talked about that. If they offer more than what we have up here for our fee under compensation of firm on page 1, we have to disclose that. Form 770 is the form to use to disclose that. Now, this is a brand new section. Buyer understands that, number 1, firm services are not free. Right? There's a lot of folks on Facebook for a long time that have advertised, it doesn't cost you anything to use a buyer's agent in North Carolina. Right? You see that all the time. That's not true. That's an antitrust violation. It's not true. So they want to make sure everybody knows that. Firm services are not free. If listing firm or seller agree to pay firm or a portion of the fee, a portion of the purchase price will be paid to a listing firm who will, in turn, pay firm as cooperating agent, explained by such and such herein. So that's saying how it's always been, right? It says if the firm or the seller agree to pay the buyer's agent, then technically the buyer is going to pay that, but it's going to come out of what they pay to the seller.
Mm-hmm.
The way it is right now, the way it's always been. That part is not changing. They still have the option to do that. This is just explaining how that worked. If the cooperating compensation offered is not sufficient to satisfy the fee, then the buyer is obligated to pay the difference unless, not allowed by law, exempted by law. We just talked about that. Now, here we talked about Form 770 may be used to disclose any potential additional compensation. I'll show you Form 770 in just a minute. Form 220 is what we would use to negotiate our commission with the listing agents. Okay.
Yeah, that's like, even though you said they've updated it, that's like what we used if they were in a different MLS.
It's exactly right. Yep. Because previously, one of the main purposes in the MLS was to ensure compensation between co-brokers. And that has gone away. So what the main purpose in the MLS is now, I don't know, but we still are using it for the moment. So we'll look at both of those forms, talk more about that here in a few minutes. They changed the word commission to compensation. So you won't see commission anywhere in these forms anymore. It's all going to be compensation. And they wanted to make sure that everybody knew that all these terms are fully negotiable between the buyer and the firm. That's the big changes on here. There's a couple of other little tiny small things. I think. Oh, that's it.
This may sound ignorant, but what's the difference between compensation and commission?
So it doesn't. There's not, right? Commission is a type of compensation, but you could have a flat fee, which technically, I guess, is still commission. I don't know. That's just what they decided to do. I don't have a solid answer for you on that. I'm sorry.
No, that's fine. It's more the verbiage of it than
It is
really anything. Okay.
But the big changes are, again, that we have to make sure they initial this up here saying that they understand that they're not required or the listing agent or seller is not required to pay us. And that if they don't pay us or don't pay us enough, then the buyer is on the hook for the rest or for all of it if they're not offering compensation. Know that you're not going to be able to look in the MLS anymore to see what that co-broker compensation is. You're going to have to reach out to a listing agent before you show a property every time. Not before you submit an offer, but before you show the property. That is the time to negotiate your fee, before you show the property. And then we have these two forms to negotiate that, Form 220, or if there's a change, if they're offering more than what we have agreed to with our buyer, then Form 770 is the one that's used to disclose that information. Wow. Those are the big things.
So we reach out to them via that form, like via email.
Via email, phone call, text message, whatever. And what should be happening is listing agents should have this Form 220 ready to go. Now they can't upload it to the MLS. That's an MLS violation. Okay. So they're going to it's going to be a burden on you as a listing agent. Every time somebody requests to show the property, you're going to have to shoot that over to them so they know what you are offering. If they don't like it, they can come back to you and say, hey, that's great. My buyer's really interested. But I think that we need to have this at 3% commission. Are you able to make that work? And if so, you get the Form 220 uploaded. Questions on the buyer agency?
Mm-mm.
All right. Now, there is a non-exclusive buyer's agency agreement. The only change, so let me go to this. Have you ever actually looked at this form?
I don't think
We
that
don't
I
use
have.
it. I've never used it, at least. Basically, the only difference, in a practical way between this and the exclusive buyer's agency is if you have a non-exclusive buyer's agency, this allows them to still use whoever they want. It ties you down, but doesn't tie them down. Pretty well what it boils down to. We've always had the option to use this form. I just never have. All the changes on here mirror exactly what we just talked about. Just talks about the compensation stuff. It's a little bit shorter form. It's only 5 pages. Let's go ahead and look at Form 220 since we were just talking about it. This is called Cooperating Compensation Agreement. Again, they kept the same name, but the entire form is brand new. So every single thing on here is yellow. Excuse me. Only use this form to create an agreement for cooperating compensation if a seller is represented by a licensed real estate broker. There's another form that you would use if it was a FSBO. I'll have to go back and look and see which one that is. I don't remember off the top of my head. Oh, here it says use Form 150 if you're doing this with an unrepresented seller, meaning a FSBO. Do not, in capital letters, do not upload this form to the MLS. So I have not heard what Canopy is or is not doing for violations for this, but I know in my MLS down here, the first time you break this rule, first time anything related to compensation is offered in the MLS, you get a written warning. The second time, you get a $500 fine. Your BIC also gets a $500 fine. The second time, okay? Fool me once, shame on you. Fool me twice, they're going to get us all. So I assume the Canopy is going to do something similar. I'll point that out simply to say that I'm not paying the $500 fine. Y'all are. So please don't mess it up if you don't pay $1,000. And let's make sure we're doing everything in the right way. So scroll on down because all this stuff up here has all been struck through. We identify the seller, we identify the property, and we identify the buyer. The fee, check only one, either the seller or the listing firm agrees to pay selling firm cooperating compensation as follows. So this is new too. Used to, all of our compensation came from the listing firm, right? The listing firm had an agreement with the seller. The seller says, yes, I'll pay you X%. And then the listing firm agrees to give a certain percent of their X% to a buyer's agent. This now allows the seller to pay directly to the buyer's agent's firm. It would still show up, in the, I guess the exact same way. It'd have to be a very similar way on the closing disclosure and or HUD. It's just coming straight from the seller and not from the listing agent. So we can either do a percentage of the gross sale price. We can do a flat fee of blank, or you can do other. And I don't really know what other would be. I mean, if you want to put in there the boat that's in the backyard or something, I don't know, but
2 chickens and a goat.
yeah, 3 chickens and a goat. They used to give cruises out. Listing agents used to do that for buyer's agents. Payment of the fee. This just says that it is due at closing. This agreement shall be effective when signed by seller or listing firm and will terminate upon the earlier of closing as defined in the contract, or you can put a date in right here. Okay. Now, if the fee has been earned prior to the expiration in this paragraph, this agreement shall not terminate and it will continue to be in full force and effect until closing as defined by the contract or until the contract is terminated. So what that means is, let's just say they have, August the 15th here on the expiration date, and that our settlement date was going to be August the 17th. That's 2 days later. But our closing got delayed. So we have until August the 24th to get this wrapped up for the current contract. Even though the expiration date is passed, since this agreement was signed before the expiration date, then we're still good until the 24th when that contract would either close or expire. That makes sense?
Mm-hmm.
Sorry, I don't know why it keeps doing that. Now, it used to be voluntary whether the seller and the buyer signed this form. It is no longer voluntary. Both the seller, the buyer, the listing agent, and the buyer's agent, a minimum of 4 parties, have to sign this form each and every time.
Okay.
That way nobody can say they didn't know. This is
Who initiates that form? The buyer's agent?
So it depends on the situation. Most often, what I anticipate, at least, this is brand new, so I can't say for sure, but what I anticipate is that listing agents will start sending this to buyers agents, when us showing a schedule. As you'll see in a minute on the exclusive right to sell and listing agreement, they still have a spot on there for what we're going to offer to a buyer's agent. So that's not changed, right? They still have that election to make. So I anticipate this just being emailed out. One potential solution would be for this form to be uploaded to Showing Time or Broker Bay or whatever, scheduling solution that particular MLS uses. That way it's not on the MLS, it's not public facing. Only agents who have scheduled showings have access to it. That would be a simple solution, but at the moment, that's not what they're doing.
Do you know if that's allowed or not? Because I know
To my knowledge, it is.
Okay.
Yeah. So we talked about that in a class I took on this the other day. And the best that we could figure, yes, it is allowed. And nobody's doing it though. You can, by the way, we're not to the listing side, but while we're talking about it, you can still advertise the offer of compensation. You just cannot do it in the MLS. You can still put it on your personal website. Within certain criteria, you can put it on social media. It just can't be anywhere on the MLS or connected to the MLS or in documents on the MLS. If it has to do with the MLS, you cannot have it on. And obviously, there's a lot of changes and a lot of forms. We're just going to look at the main ones, the ones that we use all the time. And then at some other time, we can go more in detail on some of these things that are, not used every day. Let's look at your offer to purchase contract real quick. Form 2T. This is for residential. There's not many changes on here. They changed this instead of saying time being of the essence, it just says time is of the essence. So here is a new sentence, and this actually was allowed before. It just wasn't explicitly laid out in the contract. It was laid out in the guidelines of how to complete the Form 2T. But it says seller or seller's agent may direct buyer in writing to make the due diligence fee payable to a party other than the seller, as the term is defined herein. The seller agrees to be bound by such written direction. So I don't know who you would ever make out in DD2 besides the seller, but you have the option now. So due diligence period, instead of just having the date drop down like it's had forever, we can now write in a date. We can write in 30 days, whatever you want to put in there. Period being on the effective date extending through 5 p.m. on, insert date only, not NA, or you can write down here. The period extending for, again, insert number only, not NA, blank days after the effective date. So you can put in a date, or you can come in here and say 14 days after the effective date. And what that saves you from is when we submit an offer and we do a 2-week due diligence period, and dang, it took 4 freaking days for them to sign the contract and get it back to us. We've lost 4 days of our due diligence period. We only have 10 days now. So instead of having to go back and make the changes and so on and so forth, if you just choose this box and put 14 days or whatever you want it to be, then the time doesn't start until all parties have signed this contract to make it effective. Does that make sense? Another change. This is not going to affect you as much as it's going to affect me down here. Whereas this paragraph used to just talk about flood hazard, it now says flood, wetland, and water hazard. Investigation of the potential flash floods, wetlands, or other water or riparian issues on the property and or requirement to purchase flood insurance in order to obtain a loan. So what this is saying, this is under buyer's duties or due diligence period, I guess. Yeah, buyer's due diligence process. This is saying part of what the buyer is supposed to do, and you as the buyer's agent, is make sure there's no wetlands or other riparian issues, not just a flood zone, which is something you should have been doing already. They're trying to make sure that everything is very clear. How could you look and see or get a good idea at least if a property has any designated wetlands? Really, it's just talking about the big ones like 404 wetlands that are, FEMA regulated and such, DEQ regulated. Any idea how you could figure that out or have a good idea at least?
Yeah, that makes sense to me. Because I feel like that was already something, especially with Well, even if there was a home, sorry,
You're fine.
um, or land, that was something I always checked to begin with.
How would you check for wetlands?
I haven't had a site because I've done more of the listings, but there's a website that you use. You can go on GIS layers and look at like the 500 and 100 year.
You
Like,
can, absolutely. So the first place to start would always be GIS, in my opinion. It's a great
Okay.
starting place. There are websites out there that you can view this on. The only way to know for sure is to have a survey, right? But most buyers are not going to have a survey. Excuse me. But call the local DEQ, Department of Environmental
Quality.
Environmental Quality. Yeah. They have regional offices. And if you give them an address or a property ID number and tell them what county it's in, they can give you a really, really good idea of if wetlands are something you should be concerned about on that particular property or not.
Okay.
Right. All right. Excuse me. This was added as well. Apparently, there was an issue with sellers not providing HOA information to the closing attorneys. So this is just saying that the seller shall provide to the closing attorney all information needed to get information on the HOA management company. Make sure that there's no outstanding HOA fees or anything like that. Gotta give reasonable access to the property. If the buyer establishes that a violation exists, talking about governmental compliance, after the effective date and prior to closing, the buyer must promptly notify seller. That's always been the case, right? Because material facts go both ways. If you as a buyer's agent learn something about the property, you should share that with the listing agent. Now, this is important though. Seller may cure the violations unless otherwise agreed. If seller does not cure the violations prior to closing, then the buyer may choose to accept the violations and proceed to closing or terminate this contract and receive a refund of the earnest money and the due diligence fee. This is the only.
That's never happened before.
It is, right? So, but this is not new, right? It's always been in there because it's not yellow. So again, I can read these things. You read these things 100 times, and every time I read this contract, there's something else that pops out like, good grief, I didn't realize that. So let's keep that in mind.
Dude.
All right, that's all the changes on the 2T offer to purchase. Any questions on that? Just make sure that every form you're using says 724 down at the bottom right. In our dot loop, they all should, but obviously, I tried to show you a minute ago, it didn't save for whatever reason, my new template. So I'll go back in there. Just make sure they say 724. If you're listing a property and you get documents from a buyer's agent, make sure they're using the updated forms. If not, you can tell them that you need the updated forms. Okay. So I'm not going to pull up the buyer's agency, or excuse me, buyer's possession agreement. So buyer's possession after closing, this has always been the case, but they just added a new line in it to make sure that everybody knows this. If you do buyer's possession before closing, the buyer waives their rights under paragraph 8.8. Here's pull it up, look at it. That way I can tell you for sure. Excuse me. So when they move in, that is them accepting the property in its current condition. You can't come back 3 weeks later after you've been living in there and say, hey, you know what? Actually, there was a hole in the drywall in the bedroom, Mr. Seller. And before we actually close, I'm going to need you to fix that. I've been living here for 3 weeks. The moment that they move into that property, their right to, do any of that is gone. That's the only change in this whole form. Thankfully, we don't do enough buyer's possession to have to worry about too much of that. The agreement to amend the contract, Form 4T, we use that a whole lot, and there's some really cool changes to this. Excuse me. All right, so one of the more common things that we use this form for in the past, or try to use this form for in the past, is to add a buyer to the contract. I don't know about you, but I've had quite a few where, we started off with let's say it's a cash purchase, and only the husband was going to be on the purchase contract, and for whatever reason, halfway through, they decide, you know what, my wife needs to be on there too. Or you have a lender that says, well, actually the pre-qualification was in both of their names. And so we need to add, the other party to this contract, or whatever the case may be. There's lots of circumstances that could necessitate someone needing to be added to the contract. In the past, there was no good way to do that. And you would either have to go back and strike through everything and have the attorney do an addendum, blah, blah, blah. But this has a new box. We can just check here, check that box, and insert the name of the person right there. And that's how we add them to the contract. Super simple. Hopefully in the future, they'll do the same thing, but do one to remove someone from the contract, because that's also a common issue. That's the only change on this one. Cool. I think you're frozen, Maddie. Can you still hear me? Give her a second to get loaded back up here.
Can you hear me, Chris?
I can. Can you hear me? There you are. I've got you back. Can you hear me okay?
Yep. I got
Okay.
you. Can you hear
Sorry
me?
What's that? You're frozen again. Can you hear me now? I'm going to keep rolling, and then I'll upload this so you can see what we missed as
Am
well.
I frozen?
Oh, there you are. I've got you. Yep, you're good now. Can you hear me? Yeah, you're still frozen. I'm just going to roll with it. Here we go. You're unfrozen now. And now you completely disappeared. All right. So one of the new forms is called the estate property flowchart. And this is awesome because estates are hard to figure out, right? When somebody dies, there's a lot of legal stuff that happens. At the very tip of the top, make sure you know that you are strongly advised to consult with an attorney before entering into any type of agency relationship involving an estate, right? Dead people can't own real property. They can't sign contracts. So you have to make sure that you know exactly who is supposed to sign that contract. That way, you know that you've got everything taken care of you're supposed to. That way, you don't get, a week from closing just to learn that, oh, there was actually another heir that lives in another state that is going to take another month to get in touch with, or they don't want to sell. There's always that possibility. So use this flow chart to figure out who is supposed to be signing your documents. Always consult an attorney as well. I'm not going to go through the whole flow chart. It's pretty self-explanatory, but this is a fantastic form. I have dealt with a lot of estates in the last couple of years. Vacant land, again, I do a lot of that, and there are a lot of estate sellers, heirs to land that, they inherit it, they live somewhere else, they have no use for this 20-acre parcel that grandma owned for 110 years, so they want to sell it. So use this to your advantage, estate property flow chart. I think I've got you now, Maddie. Can you hear me?
Yeah, I can hear you. Sorry,
Okay.
I just moved a little bit. I
problem at
thought
all.
it would help.
Since we were recording, I just went ahead and rolled with it, and I'll upload that, and you can take a look at the time there that you cut out.
Okay.
All right, let's look at the listing side now. So the exclusive right to sell and listing agreement. There's not a ton of changes on this one, definitely less than on the buyer's agency agreement, but there are still some things to look at. Down here on page 4. Again, with additional compensation, we just have to make sure that everything is disclosed. Okay, we can use that same form 770. In bold letters, the amount, format, or rate of real estate compensation is not fixed by law, but is set by each broker individually and is fully negotiable. Again, they want to make darn sure that everybody knows that, X% is not the norm, so to speak. Everything's negotiable. Seller understands that cooperating compensation is not required and the seller has no obligation to offer cooperating compensation. You will probably have to explain to your seller what cooperating compensation means. We still have the same boxes here that we always had though, right? We always take that second and do whatever percent there for buyer's agents. Any due diligence fee will be paid to either the seller or another party, right? We check the seller. That's what's going to be most commonly. Again, I don't know who in the world the other party would be that you're paying due diligence to. I mean, maybe they want it to go to the attorney's office or something too. I don't know, but this is an option to choose one or the other. And this is where they will make that direction to you as the listing agent on who that is to be paid to. That way you can make that disclosure to the buyer's agent. Now, going back here again, we're adding wetlands. So whereas this used to just say, is the property in a flood zone, FEMA designated flood zone, and do you currently carry flood insurance? Those are the only two questions. Now we have added, is it in a flood zone or federal, state, flood zone or a wetland area? I thought I saw wetland. Hold on. Wetlands here. Here we go. The property is affected by other water or riparian issues such as creek buffers or wetlands. If yes, please provide detail. More than likely, your seller's not going to know this information. It's your job to help them figure it out. Again, relocation company disclosure. Same thing on the listing side. And that's all for the listing side. There's not many changes on that. Any questions on it? I know I'm kind of blowing through these. Am I going too fast?
No,
Okay.
I I kind of like it like this, but I would also, if possible, like to get the highlighted version so I can like reference it when I'm doing the forms.
Absolutely. I'll send you this exactly what I'm looking at. And all you have to do
No.
is click on the blue and it takes you straight to the highlighted version.
Okay, perfect.
Okay. I'll send that to all of you.
Okay.
Let's look at the listing agreement for vacant land. Again, not many changes. The changes that are present are pretty well going to reflect the ones on the listing agreement for residential property. Same thing there, same thing here. Same thing here. Same thing there. That's it. So all the changes are identical. Now, this is a brand new form. This is what I was telling you about to begin with. Any vacant land, whether it is residential, whether it's recreational, whether it's commercial, vacant land disclosure statement. You can see it looks like an archaic form. This is what the R codes used to look like. But it is a 4-page disclosure for vacant land. And it asks about title insurance issues. It asks about deeds. It asks about zoning. It asks about rivers, lakes, wells, all kinds of stuff. I mean, this is an absolutely detailed disclosure. The seller still has the right to choose yes, no, or no representation for all questions. Okay. Now you still have the duty to discover and disclose any material facts. This is a great place to start. These are the things that you should be thinking about when you think about vacant land. You should be able to research, or you should research all of these potential issues before listing this property. So use this as kind of a checklist for yourself in figuring out what material facts exist. Again, this is required by contract law. It's not required by general statute law. Does that make sense?
Yeah, and I know it's more paperwork, but I'm glad to see that with land.
Me too, because before there have been no required disclosures, and a MOG is still not required. This is the only required disclosure for that. Again, not required by law, but required by contracts. There's another new form. This one is specifically for sellers. This basically gives them a checklist of what to do and what to expect going through the listing and settlement process, which is cool because these are questions that everybody has that just condensed it all to one page. So you can give this to your sellers. There's no place to sign or anything. This isn't a required form. It's just a helpful form they created.
That is something that I've noticed a lot of them want help with. So
It
having that
is.
checklist is awesome.
Absolutely. We're not going to go through Form 800T. That is specifically for new construction. There's a ton of changes. None of us do enough new construction to take all the time that would be needed to go through that. So if and when you have new construction, we'll go through that at that time. There was one other, hold on, I want to show you. Trying to remember what it was. Maybe not. Guess that was all. So those are the major changes. Again, make sure you're using the 2024 version of all these forms. When you go into dotloop, we're not going to add a template on here because apparently the templates didn't save. See if they, yeah. So when I go to documents, we're going to add documents from a template. Where we used to go to 2023, 2024 in-car interactive, now you want to go to 2024, 2025 in-car interactive, okay? If you just type up here, you're going to get choices, options from both. So we don't want to do that. We want to not click that checkbox. It's going to put all of them in there. You can either scroll down through here, or if you do type, just make sure that it says out here to the side, July 1st, 2024, before you add it to your loop. And I'll work to figure out why those templates don't save. Well, that's pretty much it. I just wanted to make sure we had a chance to look at each of those. We will talk more about the changes regarding the MLS and stuff when it gets a little bit closer to time. Those changes don't go into effect until August 17th.
So what made these changes go into effect now
That's a really
versus
good question. I don't know the answer. Yeah.
okay.
I don't know if North Carolina's just trying to be preemptive, which I mean, I would if I was them, but
Yeah.
I assume that's the case, but I don't know that for sure.
Okay. I mean, I can't really say that I blame them. Just like, okay, let's go ahead. We're gonna be doing this. Let's go ahead and get started, you know?
Right.
So, um, but no, that really helps kind of going through it and then pointing it out because then I can kind of mentally remember, okay, this was different. This is what was different. But then I have the
Yeah,
reference point for what it needs to be.
absolutely.
So,
Have you been seeing my screen for the last like 10 minutes?
yeah.
Okay. I just went to stop sharing and it like brought it up like I was going to share it. So I just want to make sure it was actually sharing.
Mhm.
All right, cool deal. Well, any questions at all on those?
Um, does this impact like if we have something under contract now?
So no, it's just everything going forward. We
Okay.
want to use these new forms. Everything that's on the old forms, keep them on the old forms. Now, once the MLS stuff changes, then we have to follow the new MLS rules, right? So if you've got a listing that is live now, or that was live before July 1st, and it's still live after August the 17th, then we can't all advertise the offer of compensation in MLS anymore. It's really the big change there.
Okay. Yeah, because we're supposed to close on the 11th for my listing, but then I have another one under contract with the buyer for I think the 23rd. So I guess they would have to change that on their end, right? Or no,
Yeah,
you said August. Sorry.
August 17th is the change in the MLS. The forms, anything that you do from this point forward, from yesterday forward, use the new forms.
Got it. And sorry for my
Oh,
assistant.
no worries. It's good company.
Yeah.
Hey, buddy.